We will call the first case, People v. Bonds. Good morning, counsel. This is a 15-minute mini oral argument on the application. You have a 2-minute free fire zone, and you may reserve time if you are able.
Wonderful, thank you. It's a pleasure to be here, and may it please this honorable court. Rachel Wolfe for Demario Bonds. I do acknowledge I'll be keeping my own time, and I will attempt to save 2 minutes for rebuttal, but we do have a lot of information in this case. Demario Bonds spent 784 days in the Genesee County Jail between the date of his arrest and the date of the trial during which he was convicted. As the court knows, there was another trial before that one, but before he was ultimately convicted in this case. Time in the county jail is some of the most oppressive and restrictive conditions we can place somebody in pending trial. And for the reasons I cited in my brief, it's particularly important that we don't minimize the personal prejudice that can result from that amount of time. For 784 days then, the state was also aware, for at least most of it, that Mr. Bonds was seeking a speedy trial in this case. And throughout most of the proceedings in the lower court, there was completely unjustified inaction on the part of the state. This shouldn't have happened, but it will happen again if this court does not take prompt action. Prior decisions of this court and the Court of Appeals have bastardized the Barker test from the U.S. Supreme Court to the point that it's been stripped of almost any real application in the state of Michigan. In declining to enforce the presumption of prejudice and assigning a, quote, neutral tint to almost all government delay, the state has shifted responsibility for enforcement of this right back onto the accused. And in treating demonstrable prejudice to the trial defense as dispositive, the state has placed an excessive and in almost all cases impossible burden to prove any violation of the right to a speedy trial back on defendant. And that's, of course, irrespective of any diligence or lack thereof by the state. Michigan Appellate Court's treatment of the Barker test is now completely removed from the very purpose that the Sixth Amendment was designed to serve, and that is to protect against unnecessary and oppressive pretrial restraints on personal liberty while an individual is accused, presumed innocent, and awaiting trial.
Counsel, I'm wondering, you were talking about delays and the neutral tint, but in this case, your client obviously asked for new counsel, and I believe had an interest in the DNA test as well. So wasn't some of the delay attributable to your client as well?
Well, I think in all these cases, some delay is going to be acceptable. And in this case, I think, they submitted that DNA right away. The prosecutor actually submitted it, and then defense counsel said, well, since you're testing it, can you also test Mr. Frisbee's DNA as well? It's important to note that that was taken care of right during the beginning of this case. And then the request for counsel was after 7 months. At most, and I think I addressed this in my brief, at most 5 months of delay occurred as a result of him requesting that second trial. But everybody was ready to go in January of 2015, and Mr. Bond's trial did not start until January of 2016. So even if we're talking about some delay could be attributable to, the fact that defendant didn't object to, sending these DNA tests, or, multiple motions to compel were filed. Some of this delay could be attributed to the defense, but overall, over half of the delay in this case was after everyone was ready.
I have a question, and good morning. So the question I'm going to ask is, and I think this goes kind of along with Justice Welch, is what is the proportionate standard that the court should use in terms of trying to equate how to approach this when you're looking at delays? And granted, there's some delays that were caused by the defense, there's some delays that were caused by the government. How do we look at that when you have kind of a series of steps, a series of phases, a series of process that goes on? And how do we do the proportionate test to kind of figure out, based on those delays, based on those circumstances and situations that are all kind of real life scenarios, how to write an opinion or approach this case?
I think that's a really important question because this case could potentially have really broad effects. Barker makes clear, and most of its precedent as well, makes clear that what we're looking at is a balance between the reasonable diligence of the state, of the government, weighed against the extent of prejudice suffered by the accused, right? So I think overall we're looking at that balance. And when we talk about the reasons for the delay and the length of delay under Barker, what we're looking at is, the reasonableness of the prosecutor's diligence throughout the trial. And then, of course, any delay caused by the defendant is taken out of that calculus. But overall, the point is that the government here has the duty, they have the responsibility, and they have the power. They have the power to make changes. So what we need to look at is the means and mechanism by which the prosecutor or the state, any state agent, is delaying the matter, right? And what I mean by that is the longer the delay, the more justification the state needs to support that length of delay. So for example, in this case, we've got that 12 months where the trial court judge says, well, everybody's ready. In January 2015, the trial court moved the trial because there was another jury trial in her courtroom. But in her opinion, she gives a case number. That case hadn't been pending nearly as long as Mr. Bond's case. So there wasn't any attempt to prioritize cases here. There wasn't an attempt to assign a new prosecutor or move this to a different court. And given the excessive length of time and the fact that Mr. Bonds had repeatedly asserted his right, that suggests that the prejudice to him that he was suffering was substantial. And then we have to weigh that back against, okay, how
Does it matter
substantial are
that defense counsel agreed to the adjournments at the time?
we don't have any evidence in the record that defense counsel agreed to these adjournments. From that January 2015 date, the trial was rescheduled a number of times. Once, I believe the prosecutor was sick, once the prosecutor was in another courtroom. The first adjournment from January until May, 4 months, was because, as I mentioned, the trial court had another jury trial that was running in her courtroom. We also don't have any record that there was any attempt made to prioritize between those two cases,
So
which I
is
think
it
is
your
notable.
contention then that if a judge has ongoing jury trials and they can't fit it into the schedule, that's not enough, that's not an excuse?
I think that trial courts have an obligation to try and prioritize those cases where an accused has asserted his right and the parties are ready to go. So the trial judge, I'm sympathetic to the overbooking of the dockets. But in this case, Mr. Bond's case had also been sitting for over a year. All parties were ready, and there should have been some attempt made by the state at least over the following 12 months. I think that 12 months is completely inexcusable. I don't know.
Is it your position that prejudice is automatically proven based on the time in the county jail? And I don't mean to make light of that time, and the conditions of some of our county jails is not good, but is that your position?
Well, I don't think that any issue should be, or any one factor should be dispositive, or that we can necessarily say that this is proven, right? I mean, they all go into the balancing test. But I do believe that Mr. Bonds...
Once the prosecutors rebutted the presumption of prejudice, you have to do something to show your client was prejudiced, don't you?
Of course. But the prosecutor has not been made to rebut any presumptions in this case at any point. Neither the lower court nor the Court of Appeals asked or expected anything of the prosecution.
So you're relying on the presumption, or you have evidence of prejudice?
I think there's both. There's that presumption of prejudice, which triggers analysis of the other factors, shifts that burden. But actual prejudice is not just the defense to the trial. Actual prejudice is that personal prejudice, and our Supreme Court cases make that abundantly clear. In fact, I think it's important to note that in U.S. v. Marion,
I'm just trying to get this to the point of, you're saying that the personal prejudice in this case is shown by the length of time in the county jail. Did I understand you to say that, or did I misunderstand your argument?
Right, or is there something more?
No, there's the extent of prejudice here, but of course, there's the prejudice inherent in every single one of these cases, these speedy trial cases, and that's the slow passage of time ticking away, memories, evidence could be destroyed. There were, in this case, 4 witnesses who expressed some trouble remembering things that had happened. Of course, the trial occurred 4 years after the offense. And I think it's also important to note that the officer in charge retired 3 months before this, the first trial occurred in this case and caused, a lot of the issues that the court and the parties had with that undiscovered evidence causing that mistrial. So there were actual tangible effects on Mr. Bonds' case. And I think, perhaps if he had been out on bond, or perhaps if the prosecutor and the other state agencies involved here had shown that reasonable diligence throughout and had a justification for this delay, perhaps that would weigh more heavily against the prejudice in this case. But the Supreme Court makes really clear that, repeated attempts to assert your right to a speedy trial evidence that you are suffering substantial prejudice. It's one of the things they mention repeatedly. And Michigan courts for the last 50 years have given almost no substance to any claims of prejudice outside of prejudice to the defense. And that's just not the way it's supposed to work. I think I was getting back to U.S. v. Marion there about how the prejudice we're looking at in these cases is completely separate from the prejudice to the defense. And that is how they distinguish pre-arrest delay from delay after, delay after the actual accusation and the arrest, because the Supreme Court has repeatedly said, the prejudice we're looking at, if it was about prejudice to the defense, that prejudice would start to run, that clock would start ticking on the date of the offense rather than the date of the arrest, which is when the speedy trial right kicks in. So we've completely separated under U.S. Supreme Court law these two types of prejudice. And it's true that they also have said repeatedly that, this prejudice is difficult to prove and that prejudice to the defense is the most serious sort of prejudice. But they've never said that it is the most important or the single deciding factor. And Michigan courts have. I believe it's explicit in People v. Williams. It says, a lengthy delay can properly be weighed against the defendant even if, or as long as there's no prejudice to the defense. And they've made that really clear. The Court of Appeals has followed it. The trial courts follow it. And right now we're in a place where, it's easy to sort of set aside the right to a speedy trial. It's easy to, take the responsibility off of the state.
Do you know, your client has previously requested a remand for an evidentiary hearing. Do you need an evidentiary hearing to show, or does your client to show that he's entitled to relief?
If there is an evidentiary hearing, Judge, I believe that the burden would then be on the prosecutor to prove that there were substantial reasons for this delay, or to show that the delay was harmless.
So you don't need an evidentiary hearing to establish that perhaps the prejudice to the defendant personally sort of translates into prejudice to his defense?
No, I don't think at this point we do, although I will say, I think the record is really clear in this regard, especially because of the number of times he asserted his right. And then, of course, the trial court did make some finding of facts about the reasons for the delay, and both lower courts attributed most of the delay to the prosecution. But if this court were to remand, then I would ask that it be with instructions that the prosecution then has to rebut that presumption which had come into play and show either, like I said, a necessity and a reason for this delay, and then also the lack of prejudice. And I see I'm out of time. If I want to rebuttal, unless you guys have questions.
Nope.
Okay,
Go
I'll
ahead and sit
preserve
down.
my 30 seconds.
Okay.
Good morning. May it please the court, Katie Jory on behalf of the people. Defendant in this case was not denied his speedy trial, and his appellate counsel was not ineffective for raising claims that were more likely to prevail on appeal. There was no deliberate attempt by the people in this case to delay the trial to hamper the defense. Although the length of the delay is obviously less than ideal, the record shows there were understandable cause for the delay, including defendant's change of counsel, new counsel's trial schedule, new counsel's demand for different discovery that was difficult to obtain, and all in the background of a multi-jurisdictional, multi-year-long investigation into gang activity on the south side of Flint. Except for approximately one witness, the substance of the case was essentially the same at preliminary examination as it was at trial. The delay from seeking DNA results and obtaining unredacted FBI reports is at the behest of defendant. The delays would potentially help defendant find a defense that simply was not there. Defendant was also not prejudiced by the delay under MCR 6500 standards or speedy trial analysis. No defense witnesses were lost, no exculpatory evidence was lost, and no defense witnesses' memory was eroded. His trial counsel was excellent and vigorously cross-examined witnesses. The passing of time did not taint the evidence. The record shows that defendant received a fair and impartial trial. The personal prejudice alleged is essentially the same as for everyone awaiting a serious felony trial and was properly weighed by the lower courts. Finally, defendant here is a convicted murderer and habitual offender fourth. He shot and killed Michael Jones on July 7th of 2011. The remedy of dismissal with prejudice for violation of a speedy trial right is severe, and considering the valid reasons for the delay, that defendant wasn't prejudiced and received a fair and impartial trial, people would ask this court to deny defendant's application for leave to appeal. Your Honors, I want to note that the delay that was caused.
Counsel, good morning. How do you address the issue of personal prejudice that exists for such a long time being spent in the county jail?
Sure. So, first of all, the case law is very clear, even pursuant to Barker, that the personal prejudice must be taken into account, but it is the lesser of the two prejudices. The
Right.
more important prejudice is the prejudice to the defense. For a short period of time, I believe 4 months of the first 4 months of defendant's time in the county jail, he was supposed to be in the MDOC. So he would have been incarcerated no matter what during that time. Additionally, I don't believe that under the statute he was eligible for bond. He was in on murder and suspicion of murder and assault with intent to murder. Obviously, People v. Chisholm has said that a 27-month-long delay is not an insignificant personal hardship, but since there was no prejudice to a fair trial, that even though it wasn't insignificant, the factor that matters more regarding prejudice was to the defense. And in this case, I would say that obviously 26 months in the county jail, less than ideal circumstances, but it was a serious case, and in the end, there was no exculpatory evidence lost. He still had 3 witnesses. Their memory did not seem diminished over time. And so it is part of the balancing, certainly, but pursuant to Barker, pursuant to Williams, and all of the other progeny of Michigan.
So what would a defendant have to show personal prejudice? I mean, I agree with your recounting of the cases and how it's sort of historically been handled. But I also think we haven't really grappled much with personal prejudice. And so we know that 8 years is too much, that's probably, or 10 years, that's probably some sort of personal prejudice. But is there some in between?
Sure, I think that you're correct. The case law, neither at the Supreme Court nor in our state jurisprudence, has specifically laid out what is the amount of personal prejudice necessary. And I think that that's one of the reasons why is because that is hard to say. You could give examples. Perhaps somebody is acquitted and their parent or close family member passed away while they were in jail. Or, they were unable to secure a witness because they were sitting in the county jail and they were unable to speak with their attorney for whatever reason. In this case, defendant did ask to go back to the MDOC because he preferred the conditions there, but the trial judge said, no, I'm not sending you back because you have a local attorney here, and that actually, you need to talk to your local attorney here. So the other issue that I would say with personal prejudice is that speedy trial is a very fact-specific analysis. And so I believe it would be hard for anybody, including the courts, to lay down kind of a strict standard about what is enough personal prejudice, because it would depend on the case just because of the fact-specific nature of speedy trial analysis. I did want to go back just briefly to the amount of time it took from the first trial date to the first mistrial date. Yes, the court in January of 2015 was in another murder trial. I did attach that ROA because I believe that defendant was arraigned only a week after Mr. Bonds. And so the oldness of the cases, if you will, were essentially the same. And I think that a trial court judge who has two cases in front of her that are essentially the same age, and one of them is literally queued up, ready to go, let's bring the jury up, I believe at least a week, if not more, before Mr. Bonds was scheduled. That is in their discretion to take that trial and to move it along and not say, I'm sorry, but I have a case that's a week older, and in a week and a half, that one's scheduled to go. Then yes, the prosecutor was in another trial, the prosecutor was ill, and then the first mistrial, unfortunately, happened, I believe in September of 2015, and then yes, the final trial came where he was convicted, came in January of 2016. So I also sort of want to push back against the idea that the trial court and the appellate court used the wrong analysis here and put the and put the onus on the defendant to prove prejudice. I don't believe it's lost on this court that the trial court and the Court of Appeals were considering this case within the confines of a motion for relief from judgment under MCR 6500. And in fact, this court, when it remanded the case back to the Court of Appeals, specifically instructed them to look at it in the context of MCR 6.508D3. And pursuant to that court rule, the defendant has to prove good cause and actual prejudice. The assertion that appellate counsel was ineffective obviously can't be raised at appeal. That goes to the good cause argument. Both the trial counsel and the Court of Appeals framed this case regarding defendant's prejudice pursuant to that court rule. And even if they did not, the state has rebutted the presumption of prejudice in this case. As stated prior, there's nothing in the record that shows that defendant had other witnesses to testify on his behalf that were lost. There was really no exculpatory evidence that was found, even with all of the DNA testing and getting the unredacted names from the FBI. And defense witnesses, to my recollection of the record, their memories of that date, even though it was years before, was fine. Some of the prosecution witnesses had some very minor points in time where they couldn't remember things that they had told one police agency over another. Defendant's trial counsel ably cross-examined them on these discrepancies. And a lot of them were very small, such as Terry Rimmer, when he testified, he couldn't remember if he told the police that people were drunk or if people had been drinking. So, and additionally, a lot of the memory loss was actually to defendant's benefit, such as there was at least one witness who testified or who told police that Mr. Bonds told him that he shot Michael Jones. And then when he got on the stand, he said, "Oh, no, that's not what I said. He told me he was there." So things of that nature actually benefited the defendant.
Counsel, if we were to write an opinion on this, what would you really want it to say in terms of, in a case like this, dealing with personal prejudice, dealing with the other issues that we're talking about? What would you say the highlights of this opinion should be if it were to be written in the fashion that you would want it, in terms of what you believe the government should be able to do as it pertains to speedy trial?
Yes, so I think that the opinion would basically be to, for this court to reestablish the balancing factors of Barker v. Wingo. I believe it hasn't been revisited since 2006.
But what would you say the highlight would be? What would you say the main key emphasis would be in terms of this, as it pertains to if we were to balance this, how would the court balance this in a way that, I guess, what would the highlight of the balance be that the court would take with it?
Well, I'm not sure that there could be necessarily a highlight, since Barker v. Wingo says that all of the factors need to be balanced. And I don't believe that there's anything in Barker that says that one factor is more important than the other, so I don't know that I'd use the word highlight. But I think in this particular case, we would want it to say that, sure, the length of the delay pursuant to Michigan law was presumptively prejudicial, but the complexity of the case comes into play under that, which is fact-specific to this case.
And should that be a concern for other defendants who are going to be following?
The complexity?
Yeah, I mean, I guess my question is that if it basically, what we have to look at is for all the cases that follow, right?
Yes.
And the reason that speedy trial is so important is because it's really what separates the United States from so many other countries, meaning the notion that before you have the opportunity to go before a judge and jury, the government can't hold you for a long period of time. So it really is an essential component of, our democratic values. And so I guess the question I have here is that if we were to write an opinion, as it pertains to this, what are the things that we should be concerned about as it pertains to how this process is going to implicate other people that are going to follow?
Yes, and I would agree with that. I would just say that the people's position is the Michigan case law that is on the books right now doesn't need to be changed in any way, shape, or form, and that if this court were to fashion an opinion in this case, it would just follow along with the factors already set out in Barker v. Wingo and in Williams. And like I said, it's a very fact-specific right. And so I don't know that there's one thing that's highlighted over the other, but we do need to obviously acknowledge that the length of the delay was triggered in this case, and that there were reasons for the delay that were acceptable, including what this court has always said are neutral reasons, which I don't agree that is kind of a misreading of Barker. That defendant did assert his right, but that the prejudice personal in this case was essentially the same as anybody else awaiting speedy trial on a felony, especially a murder, and that there was nothing that prejudiced defendant's case. And so I see that I am almost out of time. So at this point, I would just ask if there are any further questions, and if not, then we would ask that defendant's application for leave to appeal be denied.
Thank you.
Thank you.
Ms. Wolfe, you have 32 seconds.
Thank you. If I could just take my 32 seconds here to answer your question, Justice Bernstein, about what the opinion should say. I think what this court needs to do is push back a little bit, shift that responsibility back to the state. The state has the duty to uphold the right to a speedy trial. The state has the means to affect any sort of change and provide incentives. It's not the defendant's duty to bring this forward. And personal prejudice is too much when it outweighs the government's justification for a particular delay. And seeing my time's up. Thank you.
Thank you. The case will be submitted.